Well, I'm indeed delighted to be here today. I would have loved to speak in Tamil language. But the past 1 month, I was traveling and didn't find sufficient time to gather my thoughts in one of the most wonderful languages in the world. I must thank MMBA, Mr. Samidurai, and particularly Justice Balasubramaniam to be very kind enough to be here today evening. All that has been said about me is not what is relevant for our getting together on a possibility of an enlightened conversation. I'm not on a lecture here. We are in a conversation. Justice Balasubramaniam said that give sufficient time to somebody like Mr. Venkataramani and you will churn out butter, right? I was wondering whether it is a butter which should melt quickly, a good butter or an adulterated butter. Because there are all kinds of butters, floating around us. I suppose I may be conveniently classified as a butter which melts. A butter which melts for good reasons. My very dear young friend, I call him still my young friend Lajpati Rai, before I go on to talk about the subject for the day, let me share some very broad nostalgic memories of Madurai and some broad views on the importance of developing the art of listening, the art of being part of developing a dialogue, a discussion. So lectures like this are, as I said, are not merely a unilateral flow of thoughts and ideas from one person. The idea is that we should commonly engage in certain fundamental issues of common concern for the legal fraternity, and I suppose MMBA will look at what has happened in the rest of our country. Like for instance, the Tagore Law Lectures is a great chronicle in our country. Or in England, there was a young, very moderate woman by name Hamilton. She did not belong to a rich family. So at some point of time, I'm talking about more than 150 years ago, she thought she should contribute her moderate estate to the development of law in England. So she set up a foundation called the Hamilton Lectures. Hamilton Lectures have 150 volumes of lectures today. And each one of them are priceless discussions and sharing of thoughts between the audience and men who matter in the field of law. And today we have large number of national law schools and national law school universities. And many such universities have many foundations in name of respectable persons. For instance, there is Mr. K.K. Venugopal, the M.K. Nambiar Memorial Lecture Series. So we have all kinds of lecture series in our country, in different parts of the country. But I have not seen our Advocates Association, the legal fraternity, as part of a common engagement in development of law in our country, in promoting lecture series which can become not only a matter of discussion or a debate, a matter of resource material for being even quoted in courts. And why can't such lecture series become part of a textbook or reading material for students in national law schools? So these are very general thoughts which I thought which I share with you. I know there is a lot of criticisms about the bar councils, both the Bar Council of India and the state bar councils. And some criticisms are well-meant criticisms and some perhaps are politically oriented. We need not get into that. But I suppose the entire legal fraternity in India, their contribution to the growth and development of law both before and after independence is something remarkable. If you look at what happened in USA, particularly the growth of free market ideas in US Supreme Court judgments, It is attributed to a famous lawyer called Thomas Cooley. Thomas Cooley was a lawyer, and later he had argued several cases of importance before the US Supreme Court, particularly promoting laissez-faire and free market capitalism before the US Supreme Court. I don't want to get into the detail, but lawyers like him, whose contributions to development of law and jurisprudence at the highest level, became part of the legend of law itself. And you can gather so many such instances in different parts of the world, particularly England and Germany. And we have such developing phenomena even in other Commonwealth countries like Australia and New Zealand. So I suppose that given the great road ahead which lies in front of the legal fraternity in India, and the entry of young talent in the bar, young talent coming from a variety of a diverse set of law colleges and law schools, coming from diverse socio-economic backgrounds, aspiring to be part of a great legal stream and be part of a legal evolution in our country. Having regard to all that, I suppose institutions such as MMBA would have done a great job in institutionalizing this kind of lecture series. I must tell you that we do not lack human and intellectual resources which are available in abundance in our country. You only have to tap them. You only have to identify them. And all that is required from us is as legal fraternity to be able to, the readiness to respond and be part of an intellectual discourse. Another well-founded criticism about the bar councils and the bar associations is we have ordinarily become mere centers of what called everyday gossip and things like that. I suppose, and I'm sure, with emerging leaders, young leaders of the bar, and judges like just Balasubramaniam and upcoming judges like Swaminathan, I'm sure this kind of a criticism that bar associations are meant only for laid-back exchange of meaningless, talk or gossip, I think we'll be able to keep it aside. The younger members of the bar who enter the bar today look for great amount of inspiration. And how do you offer this inspiration to them? In a variety of ways. By being a great lawyer, by being a lawyer with considerable commitment, and also all of us being wedded to pursuit of excellence. The pursuit of excellence is something which nobody can negotiate with. And if you think excellence is not necessary for the legal profession, I think probably the legal profession will be turning its back on its fundamental contribution to rule of law and evolution of law in our country. These are some very general thoughts I thought I may share with you. Not that any one of you would not have the same kind of thoughts and points of view like me. I'm not saying that I am having something very peculiar, special, exclusive, possessionist ideas. I do not say so. Many of us, and I think every one of us, in our own individual way, unique way, must be thinking on these lines, except that probably would not be in a position to pull them all together, articulate them, and share them the way we want. And when Samidurai wanted me to come here and deliver a lecture, thanks to my dear friend Arvind, was in Supreme Court. It happened about a month ago. And I told Arvind, let me think on the subject I think I may like to talk about. So I shared with him initially some ideas. Then I said a week later, no, I think I've changed my mind. So it went on almost for about 3 weeks. I was not very sure as to what I would be able to talk and share with you today. So only last week I told him that I would probably talk on this subject. The reason why I chose this subject, I'll presently come to that. Globalization specialists today, there are lots of people who specialize on what is globalization. None of us can turn our backs or close our eyes to globalization. It is something which has happened whether you want it or not. It is not the same as globalization which happened probably hundreds and thousands of years ago when people from all over East Asia went by walk, horse, camels and all forms of transport, which is called the Silk Route in those days, from China to India, across Asia to Greece and Rome. But that kind of a globalization was a very minimal level of how human beings travel from different parts of the globe particularly confined to trade. But the globalization today is something vastly different. It has overtaken us in more than one way. Why is it vastly different? It is different because the national domestic frontiers, namely sovereign democratic republic character of each and every country, is also slowly giving way. Science, internationally developed science. Technology, internationally developed technology. And communication of ideas and views in ways which probably would not imagine possible probably 50 years ago, has virtually overtaken our ability to comprehend and cope with this very enormous developments taking place at the global level. Can it be then said, if science and technology, civilization on its ability to fulfill human needs, our access to food, our access to health, our access to various fundamental aspects of life, culture, religion, can it be then said that law should lag behind? And that was the most important, I think, idea which should engage us on every day and in probably in every case which you deal with. It may appeal to be a very far-fetched idea to you, but I suppose you can trace the most simplest of a civil case which you handle in the first appeal or the second appeal. Is not far distant from the impact of globalization. I'll explain to you a little later. So today criminal cases cannot be said to be diverse from human rights. Nobody can look at CRPC without having constitutional dimensions into CRPC. Nobody will look at CRP, the right to fair trial, the right to speedy trial, the right to the fairness of trial being brought in Article 21 without impact of globalized human rights dialogue. So in a variety of ways, more than one could have dreamt of about probably 50 years ago when we adopted the Indian Constitution, the world has changed. The world legal dialogue is changing. The legal dialogue in Europe is changing. It is changing in the United States. For instance, we have borrowed good deal of law from United Kingdom. Our administrative law is nothing but English administrative law. But if you see what happened in the past 20, 30 years, our administrative law has become our constitutional law. Today there is nothing like an administrative law in our country. It is virtually a constitutional law. England is still grappling with its administrative law problems. England enacted a Human Rights Act in 1993 when it was still part of the European Union. Today it is no longer part of the European Union. But the Act of 1993 said, unlike for instance all of us know students of administrative law and English law, that English claimed that they have an unwritten constitution. The Magna Carta was said to be the basis of all the Charter of Freedoms in England. But unlike the Indian Supreme Court or the United States Supreme Court, the House of Lords for that matter, or now the UK Supreme Court, did not have the power to judicially review legislations. These courts did not have the power to strike down law. It can only say if the authority is acting beyond the law, it is ultra vires. So the English administrative law invented lots of principles and doctrines. The legitimate expectation principle, the natural justice principles, a variety of them, and pull them all together to ensure that the English governance and governmental powers within the law are exercised in the leading strings of the law, as they call it. When the 1993 Act was enacted in England, for the first time, England thought that if any of its legislations were incompatible with the European Convention, the European Human Rights Treaty, then it could be declared as incompatible. A very minimal form of judicial review, which for the first time UK enacted in the 1993 Act. But by that time, Indian Supreme Court has virtually exploded the various contours of judicial review in our country. All that I want to say is to give a broad framework of what is happening at the global level. None of us sitting in the remote parts of any of the bar associations or the bar councils can close our eyes to these global developments. If you do that, I think we are keeping ourselves away from the mainstream of legal, social, economic and political thought happening in different parts of the world. Therefore, the important question before us is that wherever we are practicing, whichever area we are practicing, at whatever level we are practicing, if you are only able to focus a little more and pay our attention a little more to what's happening at the global level and how we can impact what's happening in the rest of the world, and how the impact, if any, on us should be minimal where it is adverse and should be welcome where it is bona fide and good. So how do we therefore engage in all these conversations? If you walk into any of the law schools today, the young students who enter into the law schools, the 5-year law schools, I mean the national law schools, many law universities have come up today. You find a bubbling young mind looking for what? Not only for a professional engagement. They are looking at India as a growing country, despite all the multifarious problems which we are confronting with. This kind of talent is looking for an opportunity to participate in a fundamental social change where law can be used as a very important tool. I didn't want to merely talk about the use of law as an instrument of social change and all that. That's all well known. But my focus on the subject today will come unless we understand this larger social, global, and the connection between what's happening at the international level and India and the rest of the world.